The Supreme Court just issued a very important ruling on overtime and the payment of salaried for exempt employees under the Fair Labor Standards Act. This lawsuit was filed by a gentleman named Michael Hewitt. He was an offshore worker that worked on an oil rig for Helix Energy Solution. He would work about 84 hours a week while working offshore. Helix Energy only paid the man on a day rate, but he was making over $200,000 a year on a day rate, working 84 hours a week. The company made a very creative argument and tried to defend themselves. They claimed that Mr. Hewitt was exempt from the Fair Labor Standards Act because he is a highly compensated executive, an HCE, who is paid a salaried and made at least $100,000 a year. The trial court agreed with the company and threw the case out. Mr. Hewitt then appealed to the Fifth Circuit Court of Appeal, who agreed with him and said that he was not paid a salary since he was paid a day rate. The employee then appealed to the U.S. Supreme Court on the issue of whether or not a day rate is a salary. The Supreme Court ruled today that when you pay someone on a day rate, it's not a salary. Why? Because if someone is salaried, that means that if they work at any part of that week, they must be paid a full salary. And a day rate doesn't do that. The takeaway for employers is that if you claim that someone is exempt under the Fair Labor Standards Act from overtime, then they must perform exempt duties and they must be paid a salary, which means, according to the Supreme Court's ruling today, that if they work any part of a week, they must be paid the full salary for that week. Okay, back to work.